Hello, everyone. This is Canadian immigration lawyer, ex-immigration officer, and former high school teacher Mark Holthe jumping on a little bit late here. It was a crazy, scary morning for us, and we're running a little bit behind with this special Halloween extravaganza that is all about misrepresentation. But I'm not alone, you guys. I have a guest that's going to be joining me, and let's bring her in right now. Alicia, how are you?
I'm well. I'm well. I'm scared though, because I've been reading some misrepresentation cases.
Yes. And I think people need to be scared. And we've seen some horrific things that have been happening over the last little while. And that's what we want to share with you guys today. So, this special live stream is all about misrepresentation. And the reality is, many people just underestimate the consequences of this, how awful it is, and what it can do to destroy your hopes of coming to Canada. And, the consequence, it's pretty simple. You misrep, 5-year bar. And even then, more than likely, it's going to cause even more problems than that. So, Alicia, it's a special Halloween episode that we're doing here. Do you have any plans with the kids?
Well, it's been hard this year because, they're growing up, and so I don't get to go trick or treating with them anymore, so I thought I'd do it here.
That's awesome. I think about I think about my own kids, and they're also, my youngest is 16 now, but it's quite fun in our church group. For my adult kids, they're actually doing a trunk or treat. So I don't know if you've ever participated in a trunk or treat before. Have you ever done that? So
I've
basically,
not.
in the church parking lot, everybody gathers around, backs up their vehicles, and if you've got like a minivan or something like that, they open it up, and then everybody has candy that they're giving out from the backs of their vehicles. So you can talk about efficiency when it comes to getting this done. And so I don't know if anybody here who's watching is also a participant of that. Happy Halloween to you, Myrna. But basically, you just go vehicle to vehicle, just loading up the loot. So it's amazing. It is, yeah, it is so so efficient and effective. And I guess the young adults, they were just so tired of not having any activities. And finally, in Alberta, you can do things outside without terrible restriction. And so they made the decision that they were going to do a trunk or treat just for them. So I think I might even sneak over there and pretend that I'm a youth, and all I have to do is wear like a mask or something, and I can get my candy hoard as well. So so it's gonna be fun. All right. So on this topic, we're dealing with probably one of the most misunderstood areas, because so many times I have consultations, Alicia, with people who've used another representative or a friend, or someone has told them, don't disclose something. It's better that you don't. And in many cases, just a lack of attention to detail can also have disastrous consequences. So let's see, where would you like to start as we're looking at this topic? Where do you think would be a good place for us to start?
So I think I'd like to just jump right into a case. And so there's a case
Okay.
called Malak, and it's very recent. It's September 27th, 2021, so just a month ago, this decision came out. And it was from the federal court. So depending on the type of immigration matter that you might have, you may have an appeal to the Immigration Appeal Division or a refugee board. But if you don't, that matter's probably going to federal court. And so this is a federal court decision. It's the highest court that's going to most of the time be looking at immigration decisions. And keep in mind that the federal court is not an appeal. So it's not going to replace a positive decision with a negative decision. The federal court is looking at whether the officer, the immigration officer, made a reasonable decision. And there are only a few administrative law principles that can make something outside of the range of what's acceptable. And that normally involves a breach of justice or natural justice or procedural fairness.
What
So
does that mean,
here,
Alicia? What does that
yeah,
mean, a breach of natural justice or procedural fairness? Can you give
yeah,
a practical example to our listeners?
yeah. So for example, if an immigration officer specifically told an applicant, don't provide me this document, and then they made a decision saying you didn't provide that document, that wouldn't be fair because the officer themselves did something in the procedure of the case that was out of the ordinary that the applicant relied on to their detriment, and that ruined the application. But most of the time that doesn't happen. So really they're looking at what was on the record. So what did the applicant actually do in the application? What did the officer decide? How did they make that decision? Was it reasonable? And
Okay.
even if the court ultimately sides with the applicant and says, no, it wasn't reasonable, they don't get approved. It goes back to another officer for another decision. But in
Gotcha.
both of these cases, they're scary because the court ultimately sided with the officer. They sided with immigration. So we'll take a look here, but we'll set it up, and it's a study permit application. So the applicant's a citizen of Pakistan, and she's applying for a study permit. And in this case, she has kids in Canada. So
Mhm.
she wants to make sure to be with her kids, and she's doing her study permit application. And there is a question for any of you who have ever made an immigration application. This question appears on many, many forms. And it is a question that you absolutely need to read and understand very, very thoroughly. So maybe we can pull that up too, Mark, but it's on most of the forms. The one that it would be on is the study permit application form for an outside Canada application.
Now let's
This
see.
one's
So
a work
we
permit
have,
form.
yeah, so we've got some work permit, but the question is the same. So I'll
The-
just, that's the one I've got queued up. So for those of you who are watching, this is the form that you would complete if you're filing to apply for a work permit. And the provisions that we're looking at are pretty much mirror those in the study permit. So if we
Yeah,
scroll
so
through here, we
the
get to the
background
bottom.
declaration questions. So this is page 3. Make sure that you're looking at these. These background information questions are the same on the study permit forms and the work permit forms for outside Canada applications.
Yeah. And if you look here, you can see it's really, the first one is all about health. Okay. And that's question one, but it's the second one that everybody needs to be scared of. So maybe
Yeah.
we can just take a look at these, Alicia. The first question says, have you ever remained beyond the validity of your status, attended school without authorization, or worked without authorization in Canada?
Yeah. So, all right, have you ever remained beyond the validity of your status? A lot of people don't realize that if they come to Canada and they don't have a visa, so they just enter on a passport and it's not stamped, the default rule is you've got 6 months from the date of entry. But if you don't keep very good records and you don't remember what day it is that you came in, you better go and check your boarding pass if you flew into Canada, or if you came across a land border, you've got to do some digging to double check what day it is you physically crossed. So if you stay beyond your initial 6 months in most cases, then you have to have put in an application to extend or change your status before your status expires, before the 6 month mark. If, however, an officer has given you a shorter period of stay, then you have to leave before that or do an extension application before that. Studying without authorization or working without authorization is huge. I know we've got a blog post article on studying without authorization,
Mhm.
possibly without realizing that you have. So go check that out. But those are huge issues. In this case, though, we're looking at 2 sub B. And so
Yeah.
this is the question that the study permit application involves.
Yeah. Have you ever been refused a visa or permit, denied entry, or ordered to leave Canada or any other country or territory? Full
And
stop.
this is the problem. So if you're reading this form quickly and you're scanning it and you're not paying attention to that second clause, so have you ever been refused a visa or permit, denied entry, or ordered to leave Canada? But it's not just Canada, it's any other country or territory ever, going back to age 18.
Yeah.
So, a lot of people, if they've traveled extensively, may not have remembered things. Keep fantastic records. If you've ever been refused entry to any other country, a lot of the times for North America, it might have been a US visa refusal. So sometimes people will apply to go to the US, and if they're not successful, maybe, 5, 10 years later, they'll apply to come to Canada.
Yeah. And an interesting thing too is, for example, many times overseas US visa refusals, there isn't even an official, even They just send out this generic little piece of paper that says you refused. Too bad. It doesn't have any hardly details on it. And so many people can not even think twice about it. Oh, my visa got refused. I got the generic little slip of paper, and then they don't even think about it. But it's critical. So, and then they also ask here in sub C, have you previously applied to enter or remain in Canada? And so, even an entry with an ETA just flying in is an entry, right?
Yeah. Yep. And I can't tell you, Mark, how many times where, somebody will hire us and we're helping review an application for them. And we know they've previously applied because they're doing a subsequent application and they just,
They're in
they've clicked
Canada.
no.
Yeah.
And they haven't even thought about it. And this can torpedo your application and it can make you inadmissible for 5 years and you'd have to leave Canada and your PR hopes would be gone. So
Yeah.
this is essential to pay attention to.
Yeah.
So going back to that mallet case, this is exactly what had happened. The applicant on the study permit had said, yeah, I have been refused a visa or a permit to Canada before. So great. This is the big thing. A lot of people say no and then you're done. But in this case, she did say yes, and she disclosed the fact that she had prior Canadian visa refusals, but she forgot or she omitted to put in her US visa refusal. And this ends up being fatal to her application, and she ends up getting a 5-year bar. And the details of what happened are important. So we're going to look at this. She only entered the Canadian information. She acknowledged she could have possibly attached a separate piece of paper specifying that she had actually been refused to the US. And so this is true, right? When you're doing an application, even when you're doing the online applications, you can upload in that client information slot whatever you want, as long as
Yeah.
that document file size is under 4 megabytes. And so most people put a cover letter or they put some additional submissions. And in her case, she could have added in her cover letter all the details about that refusal because, as anybody who's filled out those applications knows, you have a character limit. So when you start typing in the boxes, once you've put yes and you have to explain, you actually can't put a very long explanation because you don't have any space to do so in the form. And this ends up not being accepted by the court as any sort of excuse at all.
Yeah. And she stated, and this is the interesting part.
Mhm.
Um, all other applications here, um, they point out that they are different applications. And she had disclosed the refused US visa in a Quebec application, right?
Mhm.
And so when you think about this, that it it doesn't matter what you've done in the past, or even up here, like I said, she had no intention right here, no intention to mislead.
Yeah.
But the courts upheld the ruthless approach that IRCC takes.
Yeah. And so if you scroll down to paragraph 10 of this
Okay.
decision, Madame Justice Strickland, who's the judge who made this decision, actually summarizes her own case. So this is the case of Wang, and it's a few years old. It's a 2018 case, but the principles still apply and they're being upheld in this case, which is a 2021 decision. And so she's summarizing the general principles concerning misrepresentation. So the section that contains misrepresentation is section 40, and it says it's supposed to be given a broad interpretation. And so
Really?
it's an extremely broad interpretation. The objective is to deter misrepresentation and maintain the integrity of the immigration process.
Yeah. And I want to step in here for a second, Alicia, because I think lots of people bring this up a lot. This is so cruel. Why is this happening? Well, the reality is immigration doesn't have too many tools in their war chest, or too many tools in their toolbox to really catch people when they're misrepresenting. And so when they don't have a lot of resources to really be able to identify, in every case, whether or not someone's telling the truth, then they have to resort to harsh punishments to deter or to scare people away from any misrepresentation. So as we go through this, the one thing that I want to let everybody know and really, really highlight to them is that if you are ever being given any advice from a helpful friend, someone online, a representative, whether they're authorized or not, and that representative is counseling you to not say something that you should, or to actively put other information in that isn't true in your application, avoid it. Run from them as fast as you can. And maybe just in the terms of misrepresentation, Alicia, it can come in two forms. Can you let
Yeah,
our listeners know what that is?
sure. So Section 40, sub 1, sub A talks about misrepresentation, and it says a permanent resident or a foreign national. So this catches both groups of people. So a foreign national is anybody who's, doesn't have status or maybe has a temporary resident permit or a visa or a study permit or a work permit, but anybody is inadmissible for misrepresentation for directly or indirectly misrepresenting or withholding material facts relating to a relevant matter that induces or could induce an error in the administration of the Immigration Refugee Protection Act.
Yeah. So you can get in trouble for not saying something every bit as much as you can get into trouble for saying something that's not true. All right, let's flip back here, Alicia.
Yeah. So looking at this, the principles of misrepresentation is they're going to interpret this as broadly as possible. And so if you keep scrolling down it involves your representative. And so if you have hired somebody who you're paying, or maybe even somebody who you're not paying, but who's making an application on your behalf, then you're still on the hook for misrep if that person puts something that's incorrect or that could induce an error in the administration of the act. So everybody has to be complete and honest and truthful. And always, honesty is the best policy. And anybody who tells you otherwise is not somebody that you should have helping with your application.
Not in any way whatsoever. Nope.
Yeah.
All right. Okay. Um, Anything else that you want to pull out of this case before, as we move forward?
Yeah, absolutely. Maybe jump on down to paragraph 24. And this is where Mark had mentioned that in this case, this is a mom, right? She wants to come visit her kids. Her kids are studying in Canada. She won't be able to see them for 5 years. And that's what happened in this case. And she said, well, you know what? I didn't intend to mislead. I had disclosed the fact that I'd had this US visa refusal on my Quebec application. And this judge quotes another judge basically saying that there's no requirement for the immigration officer to cross reference different applications. And it doesn't matter if you didn't intend to deceive. So even though you previously included this information about the US visa refusal, prior intent to include the information doesn't overcome the fact that you didn't include it this time on this application. So you are forever held to being perfect in the disclosure that you make on every application.
Yeah. And Alicia, I think of, okay, I know how we do it in our firm now, how we represent our clients. Because of these harsh provisions, we do not take any chances. In fact, we believe that when we're actively preparing the applications, us as immigration lawyers, directly with our clients, with no one in between, that it gives us one of the best methods for trying to catch any problems like this. Whereas I remember how I used to run my office. There was a time when I had 4 or 5 paralegals working in the background, helping me put applications together. And I did not have the same level of direct contact with my clients as we do now. And back then these provisions weren't applied as strictly by justices like Strickland here. But there was room for people to correct, or, they just weren't so harsh. But I think as the volumes of misrepresentation started to climb, the government decided, you know what? If people are going to lie and misrepresent, then we are going to absolutely hammer. And it's like a sledgehammer squashing a mosquito. No matter how minor, how insignificant, and regardless of your intention, you have an obligation to make sure everything is 100% correct. And so I know in the previous way I practiced, part of the reason that it led me to make this transformation was because I couldn't know for certain if the client had said something to my paralegal that they just dismissed and didn't think about, because they're not a legally trained, a lawyer or professional. And so the consequences of getting it wrong are so astronomical, those small little simple mistakes, that we completely change the model that we practice. And is it super efficient? Is it the most profitable method? No, it is not. As lawyers, having this stable full of people working underneath us that are pumping out applications that we're paying, $15 an hour to, that's way more profitable, at least for me. But I couldn't sleep at night. And so
Yeah.
when I see these cases, especially, and these are so new, like this one just came out, Alicia. When was
Last
this
month,
decision? When
September
was it?
27th. September
September the
27th.
27th, last month. This is one of the most current statements on, at least within the federal court at the initial level. This is one of the statements that is driving the ship, and this is the direction we're going.
Yeah.
All right. Okay, so let's flip back here and let's continue on with this case.
Yeah, so if you scroll down to paragraph 28, and this is where Madame Justice Strickland says, you know what, innocent, a lack of intent. So even if we'll get to the innocent mistake exception, but that doesn't apply either here. But
Yeah.
a lack of intent, so it's all about whether it was true or false. That's it.
Yeah.
Is it
Yeah.
accurate that you had a US visa refusal and you didn't disclose it? Because if that's true, then you've misrepresented.
Yeah.
And she says at paragraph 28, a lack of intent to mislead is not a factor. So the very last sentence of that paragraph, a lack of intent to mislead is not a factor in determining whether a misrepresentation occurred.
Mhm.
Right? So it doesn't matter if you didn't mean to mislead
Yeah.
immigration. If you did it, that's all they need.
Yeah. And it doesn't matter if your representative made a mistake or their paralegal made a mistake or their employee made a mistake on the application and it was completely
Yeah.
innocent.
Yep.
You can't even rely on that, right, Alicia, to say, well, it wasn't my fault. I paid them to get it right. And, they have to take some responsibility. Immigration says, we don't care. You
Yeah.
chose to hire someone, and all over the website, it says, you're not going to get any special treatment if you hire a representative, right? So we're actually held to a higher standard, when we're filing these applications on behalf of clients. But even in cases where they aren't, individuals are not representative, immigration is still just as ruthless.
Yeah. And sometimes, people are drafting a form and they're drafting this study permit application form and they've just gone through and clicked no to everything. And then they didn't
Yep.
realize, oh, wait a minute, I've got to go back and I've got to read these questions carefully. And then maybe they talk to their immigration lawyer and you say, no, absolutely, you have to put yes. And if
Yep.
they upload an old version of the form,
Yep.
same thing, they've misrepresented.
Yep.
And so it absolutely comes down to attention to detail. It comes down to being thorough. It comes down to disclosing absolutely everything and keeping very good records.
Yeah. And I can think of, Alicia, all of those 40, 50,000 people who were racing back in May to get the TR to PR pathway filed, where they had less than a day to get all the forms completed, all the information collected, everything ready to go when it opened up at 12 p.m. Eastern time. And wow, that's what we're seeing now. We're seeing lots of this misrepresentation allegations coming back because people forgot to disclose. And one of the things I'll pull up just while we're we'll pause this case just for a second, is this one right here.
Yeah.
Right? Does everybody recognize this one? Everybody who submitted a permanent resident application through the TR to PR pathway was required to complete this. So you're racing to complete it, and then you hit these questions right here, right? And there's a couple in here that are really, really important to understand. So obviously, convictions for crimes, yes, of course, you're going to disclose it. And if you don't, your record will show it. And I also have something else here that I was going to pull up, Alicia, that I forgot, which was the actual wording in the express entry disclosure and notices. And the same verbiage is in here. So all of these are within the statutory information section. But so you can see here, made previous claims for refugee protection in Canada or at a visa office abroad. And here's the cruel part, okay? So, or in any other country. And then it says here, have been refused refugee status, which if people just read that far and stop, they will miss out on the fact that it's also asking about immigration visas, permanent resident visas, Quebec selection certificates, applications to PNPs, visa or temporary resident visa to Canada or any other country. Any other
Ever,
country here,
yeah, ever
right?
since you were age 18.
Ever. Exactly. So I'm just going to zoom in so that people can see this. This is literally to Canada or any other country, any refusal that could possibly exist out there. And what
Yeah.
happens if you put no? What happens, Alicia, if you put no when you've been refused a visa to the US?
It's misrep and you're barred for 5 years. You can't submit a permanent residence application and you're
Yep.
inadmissible to Canada.
Yep. And you can see here in addition, refused admission to or ordered to leave Canada or any other country or territory. And then on the criminal side, sometimes people have been detained for various reasons or have
Yeah.
been incarcerated or put in jail.
Yeah.
Maybe you were pulled over and that it was complete abusive process by the police, or there was some other issue in your country where it really wasn't justified, but they still detained you, incarcerated, or put you in jail. Well, you have to indicate yes if that was the case.
Yeah.
Um,
And I think
Go ahead.
sometimes people assume that if they put yes to any of these questions, that's it, their application is done.
Yep.
But that is
Yes.
not necessarily the case. And first of all, you have to put yes if the accurate answer is yes. But the next thing is it requires an explanation. So
Yeah.
this is where you have a spot to
Yeah.
explain
See me
what happened.
explaining here, Alicia? I'm explaining. Okay.
You're
Let's
explaining,
let's
but
let's
guess
let's see
what?
how
You're going to get charactered out.
let's see how far I can go. Oh, I'm still now. I'm talking now. I'm into my U.S. visa, and I talked about one of them, and there's on this form right here.
Yeah.
You might have to use short form, but I'm still going here telling my story. I don't have much room to say much for detail, but you can see here, this is the space that you have. And if you do not have enough space to explain everything, and we're just about to the end here, I swear they expanded this lately, Alicia, because it didn't used to go this far. Okay, there, my computer's like freaking out now. They're like, stop.
All right. So you've got 6 lines, everybody.
One,
You've
two,
got
three,
six
four, five,
lines.
six.
Yeah.
Yeah. Wow,
And
I've
if you
got a lot typed
cannot
in there.
explain everything in those 6 lines, then you need to attach a letter of explanation and go into the details of everything. So, as Mark was saying, a detention can be broadly construed, right? If you are asked by a police officer to sit in their police car for an hour while they go do some searches, that's probably a detention or it could be a detention.
Mhm.
And so disclosing all the circumstances of anything that might be a yes answer is essential.
Awesome. Finally,
Mm.
I was my key. I had typed so much in there that it had frozen my computer up. Hopefully, no one was hearing all those beeping going on in the background. But yes, you can see there's only limited space. So, what do you do if you run out of space, Alicia? What do you do
You
here?
attach an extra sheet and you're going to
Yeah,
put that in your client information because there's
yeah,
always the ability to upload further information somewhere on every type of application.
yeah. See attached sheet
Yeah.
for further explanation, just like
Yeah.
that.
So put in the details that will fit and then say see attached sheet for further explanation. And make sure that you have scanned that and reduced it
Make sure
into
it's
a 4
included.
megabyte and
Yeah,
include it. Yes.
yeah. Anything else in Malik here?
So the last thing in Malik is just at paragraph 33. They talk about, well, what if it's an innocent mistake, right? What if you didn't mean to, or it was something inconsequential? And what if you were confused by the question? And they say, too bad. Even if you're confused by the question, in that case, the applicant similarly had said, I didn't realize that I had been refused my US visa. I didn't understand the question on 2 sub B on that background information form.
Mm-hmm.
And the court said no. If you had that visa in your possession and it had happened as a fact, then you ought to have known, you ought to have disclosed, and it's still misrepresentation.
Yeah. Heartless, cruel, no room for any movement.
Yeah.
Yeah.
So make sure that you have disclosed everything, make sure you have explained everything, make sure it is all fully present and accounted for in every application that you make. Make sure to keep a copy of all of your prior applications, because I want to show you another case, and this is a case called Hasham, and that's also a 2021 case. It's from August. And actually, the court in Malik upholds the decision in Hasham. So Hasham's 1 month older, but it's got different fact scenarios. And this you would think is a more sympathetic fact pattern, because in this case, what had happened was Mr. Hasham and his family were citizens of Afghanistan, and they were living as refugees in Tajikistan. And he had previously applied to be sponsored as part of a private refugee sponsorship program. So a group of, I don't know whether it was individuals or nonprofit groups, but a group had got together to try to sponsor him and his family. And as part of that application, they had said, well, in the application forms for your permanent residence, just put the relevant work experience when you're writing down your work history. And he was apparently a teacher, but he says that he had worked as a concrete finisher after work. So, about paragraphs 13 and 14, he talks about how he was a concrete finisher and what this private refugee sponsorship program group had told him. They said, well, if I'm not doing it officially, then just put your work as unemployed. And also at paragraph 14, if you're a teacher doing during the day and you only do concrete finishing at night, but you don't have really good records of that, then probably just claim your teaching experience is what the group had told him.
Yeah.
And
Official
what happens?
employment, right?
Yeah, yeah.
Official
So
employment.
what happens then is that for whatever reason, this resettlement plan of the organization doesn't get approved by the government. And so the whole private refugee sponsorship group that was trying to help a bunch of people was disqualified. And and then this guy says, okay, well, I'm going to try to come to Canada. And he finds an employer. So he gets an employer to go through the advertising and recruiting process, and the employer gets a labor market impact
Mhm.
assessment, an LMIA. And so now he applies for a work permit. So now this is not a permanent residence application. Now it's a temporary residence application for a work permit. However, when he's doing his work permit application, he has differences in his work history
Yeah.
in terms of what he says that he was doing. And he also says no to the question of, have you ever been refused
Yeah.
a visa to Canada or a permanent residence application? And these two things end up being fatal to his application.
One thing, Alicia, I want to point out to those that are watching. Often you will get advice from well-meaning and just in some cases just stupid individuals who encourage you to only list things that appear to strengthen or relate to whatever the work experience you need. So in this case, for this individual, he didn't include his carpenter work experience when he was applying through the refugee program, but in his work permit with the LMIA for the construction work, he didn't include his teaching experience. And so that was one of the issues that the courts, I think, really took issue with is, look, this wasn't some innocent omission, but you were calculatingly putting work history that only you wanted to put in there and weren't being honest and disclosing everything. So I think this colors a little bit of what happened in this case. And understand there's always a background that we don't see. There's always something that comes out to give the justice some reason to, to lean a little bit more heavily on the misrep side than otherwise. And so we don't know the full story as to how it all played out, but clearly that was a reality that the justice kind of keyed on.
Yeah. And the takeaway from that is most of the applications will have a permanent residence application where you have a personal history as well as an address history as well as a work history. And so in some applications, like Express Entry, for example, you're only claiming points for certain work
Mm-hmm.
history. You don't have to put that
Yep.
in your work history unless you want to claim points, but you absolutely have to put it in your personal history.
Yes. Yeah.
And so making sure that if you are looking at an application and you're not sure whether to claim it as work history or not,
Everything goes
everything
in.
goes in your personal
Yeah.
history.
Yeah. And you can say, if you are not working, provide information on what you were doing. And they give an example: unemployed, studying, traveling, retired, in jail, essentially, And so, this is the background declaration form that's on many of the, non-express entry related, the TR to PR pathway. This is what applicants had to follow through with. And you can see here, please ensure that you do not leave any gaps in time. Why? Because they want to know exactly what you were doing over the past 10 years or back to the age of 18, whichever comes first. So
Mhm.
this is something, yeah, that people just don't pay attention to. And if we go to the 1295 and we look here, it's asking for, employment history for the past 10 years. So this you don't see here that says don't leave gaps, because it's not critical in this section that you don't leave gaps. But education, you can see that's really what they're focusing on. But here they don't say that you can choose what you want to omit and what you don't want to admit. So it's crazy to see how it's been interpreted. Go
Yeah.
back to
Yeah,
Hassan
so
here.
so Mr. Hisham, so that's what had happened. He had had his private refugee sponsorship fall through. That had been closed, refused. And then when he goes to do his work permit application, this is when he gets in trouble because he doesn't disclose the same work history. And he
Yeah.
also puts no. And so the case really turns on the fact that he put no to have you ever applied or been refused a application to Canada or any other country. He put no. And of course he'd applied because he applied for PR before.
Yeah.
And so ultimately, that is why the judge upholds the officer's reasoning. Keep in mind, too, that the applicant is given a procedural fairness letter. And so before the immigration officer is going to make a finding of misrepresentation, they send a letter and they call it a procedural fairness letter that they have a short period of time within which to respond to the fact that the immigration officer thinks they've misrepresented. And that's what the applicant did in this case is he said, well, I thought that, my application wasn't refused. I thought that the whole application process through the private sponsorship program was refused, but the judge doesn't buy it.
Didn't buy it.
And also, they don't buy the fact that the work history is different.
Exactly. All right. Anything else here?
I mean, it just goes to the fact that all of whether it's a temporary residence application or a permanent residence application or the intersection of all of them, you have to keep everything straight. You have to make sure that you know what was said in each of those prior applications. Keep a copy of the exact form of the application that you've submitted with all of the supporting documents, because as soon as you put that on one application now, officers will go back and cross-reference. They don't have to go back and cross-reference if they think that, you disclosed before and now you didn't disclose, and that's going to work in your favor to say that you didn't misrepresent, but they will certainly cross-reference to show that you did misrepresent.
Yeah, absolutely. Okay, so I know we've got a lot of questions that people are queuing up, and we will absolutely take questions from you guys. But I wanted to just take a second and just pull in a whole bunch of different things that Alicia and I were brainstorming about that could potentially result in a misrep finding. And by no means is this list comprehensive. And I'm going to pull them up here. We'll see if they want to fly in. I'm not sure if they do. Maybe they don't. Let's see. This one. There we go. Okay, so this is our list, you guys. So you can see here, use of another name. There's one. We'll pull that away. Fake documents, criminal charges, travel history error, arrests and detentions, incorrect dates. And that's an important one because ultimately you have an obligation to make sure that the dates you put on your application are accurate, because that could be seen as misrep. Prior refusals, prior visa refusals, and virtually any error, any error. And I'm just going to stick that one back up because this right here, you guys, this one right here absolutely encompasses pretty much every aspect of your application. And so when we look at those, Alicia, the list is based on the broad interpretation that the courts have been instructed to take with Section 40. Ultimately, anything could result in it. And so you must be vigilant. You must be careful. You must make sure that you make no mistakes whatsoever. So, so go ahead, post questions as you're watching here. Any examples that you've had, any questions related to misrepresentation, this is your opportunity to have those answered. So let's see who is tuning in here, Alicia. So we've got Asim, good to see you. Carlos, good to see you. I'm sure it looks like Carlos is probably on the other side of Divine Villa. Carlos Centeno is probably on the other side of the world. Tramp Prunk, nice, hi. and let's see. And then we also gave a shout out to Myrna here, who had indicated that she was tuning in from Victoria. So hello to you. Lots of people are asking about when the draws are going to start. So save those for the open Q&A. And I know lots of people are saying, will there be a CEC draw today? And they come in the afternoon, so we will hang tight and wait and see if that happens. Thesura, who's a longtime follower, he says, happy Halloween to you too, Thesura. And then Divine also says, happy trick or trick. That's awesome. Okay, and lots of questions about when the next CEC will happen, and we just don't know, you guys. Okay, let's see if there's anything else. Okay, all right, so Ali, let's get to Ali's question. So he says, I have disclosed my study refusal to UK on my study and work permit for Canada, but forgot to disclose on the TR to PR application. Ali, your situation is unbelievably common. Alicia, what are your thoughts on potential? Because obviously, Ali, we don't have all the facts and we're not going to be able to say yes or no at all. But based on everything that we've seen, and we've talked about a lot of things that Ali's probably feeling a little bit of discomfort right now. But what are your thoughts on this one?
Yeah, so it depends on whether you've been refused your visa or your status. And so, because that's what the 5669 is talking about. That's what the Schedule A is talking about. And if you have been refused, it's something that you ought to have disclosed and you ought to have said yes. And it's a really tough situation because if you haven't gotten an AOR and you have no way of updating information on your application, it's really problematic. I would say, if you can, if you do have a way to link that, then perfect, you can link it and disclose it. If you are able to simply do a web form inquiry and put that information on file as soon as possible, that's absolutely better than not having it on there. But you might be in a situation where you have to withdraw an application if you know that it's incorrect before that gets processed. And of course, that's not advice. It depends entirely on the situation, and I'd never recommend that you do that without talking to somebody in depth about your application and what happened. But it's very potentially very serious.
And if we flip back and we look exactly at the questions that were on the TR to PR pathway, we can see here, like I said, have you ever been refused a visitor or temporary resident visa to Canada or any other country or territory? So, and we've seen with the case law how cruel they can be. So I think in this situation, absolutely, you're going to want to try to do everything you can to correct the file as soon as possible. Alicia, do you have any kind of patterns or thresholds where the misrepresentation is such that you think, I really should try to withdraw that application and not proceed forward before it actually gets into an officer's hands? Because that is one of the possible options. One is to try to correct it and update them. We know with the TR to PR pathway that it's really hard to add anything to that application until after the AOR. And even then, the web form doesn't really allow for an easy method for updating a TR to PR pathway.
Yeah. So Normally, what I do if somebody comes to me and says this has happened is I take a look at their entire application. And so I would want to see what's their personal history, what's their work history, what was every single document that they included as part of that application. Because sometimes when you start to dig down and ask people questions, well, somebody's told them not to disclose a whole chunk of
Yeah.
their life. And that's just going to be a recipe for disaster. So it really depends on whether there was some sort of hiding or, failing to um, or omitting an entire chunk of their history that they didn't want to bring to light, or whether it was somehow just an error when they were going through that form quickly. They didn't put it on there, and maybe there's a reason. Maybe they can explain it. But from immigration's perspective, we'll see what happens with the TR to PR, because technically it was under the humanitarian and compassionate
Mhm.
jurisdiction, right? That was the whole stream was run through Section 25. So there may be a little bit possibly more leniency by officers reviewing these specific TR to PR cases, but not so for express entry, not so for study permits or work permits.
Mhm. All right. Well, good luck, Ali. Um, our heart goes out to you, my friend, because you are amongst many, many individuals who was in that situation. So, all right. George. Okay, so here's George. Let me see if I can stretch this out a bit so we can get the full comments in here. All right, let's see here. So George says, I'm going to be needy over here. Is there any way you can provide a written summary at the end of this video recapping all the scenarios that caused misrep that you discussed today? So,
So George, what we can do is we can give you the citations for those cases. You can look them up really easily. They're publicly available on the federal court website. So 2021 FC 1004 is that Malik case, and that has the most of the case law in it. And the 2021 FC 880 is the Hasham case. But the problem with misrep, everybody, is that it depends entirely on the facts of that specific case. And so we can extrapolate principles from these cases, but the overarching theme is that you must be absolutely perfect in your applications and
yeah,
everything has to be 100% accurate all the time.
yeah, absolutely. And just to reiterate, any errors, use of another name. Oh, let's move any errors down here. Oh, there's a big one. Let's leave that one right there. Any errors. Prior visa refusals, refused applications, incorrect dates, travel history errors, arrests and detentions, detentions being the key one, travel history error, criminal charges. So those are just a fraction of what potentially could, but the key here is that any errors can. And that's why, like, lots of people say, oh, this is something, Alicia, that I see a lot of, where people say, well, it's easy. It's easy to file these applications and anybody can do it. You don't need to hire anyone to help you. You can do it on your own. And in fairness, filling out a form, it has a question and an answer. You answer the question correctly, there are no problems. But like you pointed out, often people are confused by what it's asking, or they're in a hurry, or their attention to detail isn't great, or they don't take the time necessary to make darn sure that their dates are accurate with what they were working, or they're under some misapprehension because of something they've watched, online or learned online or in a WhatsApp group that where people say, "Oh, you're going to get your application refused if you disclose that, so don't disclose it." Those kinds of things are happening all the time. And so, yes. Okay, and you can see here, Kevin also, he said, I made a mistake in the 5669 form. And that is so common. Let's see here. Okay, here's one. Raj says, I applied for a US J1 visa, but the visa interviewer gave passport back and said, without placement, we cannot give you visa. But she did not give me any rejection form. Will this be counted as a visa refusal? Okay, so here's what I want to see. I think I can move this. Oh, I can't quite. Maybe I can. Yes. Okay, I want to pull something up here, Alicia, and I'm not sure the best way of doing this. Let's see here. Is this the best way? Maybe. Okay. I've got limited space here, but I do want to pull this in, and it's going to cover my whole screen, but well, I don't like that. That didn't work very good. Let me try something else here. I want to be able to put something on the screen here that we can look at together. So, I have to be careful with how I do this. I'll be sharing my whole screen. Okay, let me see if I can do this, because this is really important here. Okay, so if we go here and we go to preview, yes, I think this is going to work. Okay, just give me a second, guys. I want to try to see if I can get this more visible here so that you can actually see everything. Oh, haha, there we go. Okay, so this is what appears in your Express Entry applications, and it's actually only on the profile side. This level of detail isn't listed in the EAPR. Sometimes I think that, they don't want to let you know so that they can catch you. But you can see here, this is the notice of disclosure of personal information right here. And it says the information that you provide to immigration in your Express Entry profile and in anything else is collected pursuant to blah, 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 the IRPA, consistent with the Privacy Act. We use this information, you can see, to rank your profile against all other candidates in the pool if you are invited to apply. Great, that's all nice. We will use the information to assess if you're eligible. Okay, that makes sense. And if you are admissible to Canada. And then I've got I cut this out, but then you go down to here, you can see that IRCC, you're authorizing IRCC, well, basically to share your information with everyone. So it says IRCC is authorized to enter agreements to share information with foreign governments. And a part of these agreements, they automatically share immigration information with, and here's the 4 countries: the US, to prevent identity fraud and to identify those who have committed serious crimes. For example, well, I can tell you that they don't care as much about serious crimes as they are about fishing for prior visa refusals. And when you have full access to the US database, that's where people are getting caught. And then it says here, information shared includes biographic information, name, date of birth, and biometric information, fingerprints. In addition, IRCC shares information with the United Kingdom, Australia, New Zealand for similar purposes. So understand that this is something that you are being made aware of, and it's being fully disclosed. So let's see if I can close this for a second. And I think I can. Yes, I can. Okay, now let me just try to adjust this size here. And this is something else that I want everybody to see. There, I think that works. Okay, this is the signatory. This is the signatory page. So I agree that by submitting this application, I'm electronically signing. Great. Then you put your name in, and I solemnly declare that the information I've provided is true and that the documents I am submitting in support of my application are genuine and have not been altered in any way. So you are setting yourself up. You are really setting yourself up for issues if you do not understand what immigration can do in the background. And there is very few circumstances where you can, where you cannot conceal, where you cannot disclose something that it won't come back to bite you. And so, yeah. So applied for the US J1 visa. The visa interviewer gave the passport back and said, without placement, we cannot give you a visa, but she did not give me any rejection form. And I think if it was India, that rejection form is just this generic template that they send back. Will this be counted as visa refusal? It will be on the US system. That refusal will be on the US system. And
when in doubt,
could very
put
well.
all the details. Yeah.
Yep, everything. And they may not have told you. And that's what we see with many Indian clients, especially. But it's a reality, you guys. And it's something that you have to face. And so back to the issue of, oh, you don't need to hire a representative. Well, our job as immigration lawyers is to get this right. And when I run into these questions with my clients and I'm going through it, when we're doing our collaborative reviews, I go to great lengths to ask them every way I can possibly think. In fact, Alicia, I actually, I approach it like I did on the border when people were coming through when I was an officer. Have you ever been fingerprinted? Have you ever been arrested? Have you ever been detained? Have you ever been convicted of a felony or misdemeanor in the US? And likewise, I take that same approach to make sure that they can't just say, oh, well, you asked if I was convicted of an offense, but I wasn't convicted. I was just arrested and detained, and I wasn't aware that that was actually on the record. And with clients, the question is, are you sure you've never, ever been refused entry to any country, anywhere in the world? Have your parents ever applied for an application for you ever? Did you apply for a work permit where the employer could have submitted it through their counsel and you got a refusal? So going to great lengths to try to save people from themselves. That's what we do. Okay.
And the other thing on that detention and arrest, Mark, and I mean, it's a whole other podcast or
Yeah.
uh, video to get
Mm-hmm.
into it, but
Mm-hmm.
if you're talking about, well, I don't think that I've been arrested or detained because I got an absolute discharge or
Yep.
I had my record
Yep.
expunged
Yep.
or, now the passage of time in my jurisdiction means that it's been wiped from my records. That
Yep.
doesn't matter for immigration purposes. If you ever were detained or charged, even if that conviction ultimately was not upheld or appealed or overturned, you
Yep.
must disclose it.
Yep. Absolutely. And it's as simple as that. What do? Answer every question truthfully, go to great lengths to ensure everything is accurate, and where, for whatever reason, you are not able to fill the information, all of the information in the box provided, or whether the question is confusing and you're not quite sure, use letters of explanation as a shield to protect yourself from misrepresentation findings. So
But also,
sometimes you're just, go ahead, Alicia.
go talk to a lawyer. Go talk to
Yeah.
somebody who has dealt with this before to understand exactly what you're getting into.
Mhm. This is a little bit offside, but we'll pull up Halima's question here. And this is a little bit outside, but we'll talk about it. It says, is it acceptable that the translator only mentioned these stamps? So for an English document with Arabic stamps, it is acceptable that the translator only mention these stamps and translate them without recopying the English words? And the answer is yes, that's not a problem. Okay. Let's see here what else we have. Okay, and we've got another one from Halima. It says, should I mention the travel history between my country of residence and my country of origin? So this is something that I do. So when I read the express entry EAPR information, it says that you need to disclose all travel outside of your country of origin or country of residence. Well, I take the position when I'm disclosing any travel, I include anything that is away from where my address is, where I leave and then come back. And so if in doubt, disclose it. All right, let's see what else we have here. If there's any other questions that are in line with our scary Halloween special here. And I think many of you probably are well aware. Let's see if we can pull it up here. So, if this hasn't scared you by now, then I don't know what will. There there are so many areas that you can get tripped up without even knowing that they're happening. And let me just see here if I can give you an example here of that spider dropping. Understand that they will catch you unaware. And I kind of use that as an example, that little spider, because often what happens is you won't even know what you don't know. And when this comes back to bite you, when you literally have, you've got this spider dropping in, and I'm not going to equate a visa officer to a spider, but the reality is, the problem you run into is you don't know until it's too late. And one of the signs that we see a lot is a request letter. So a request letter is different than a procedural fairness letter. So a request letter is just saying, hey, could you give us another copy of your background declaration? Could you resubmit it? There's maybe some dates that are uncertain. Well, that's one little strategy. And embedded within there, they may know that there is a US visa refusal, but they're just waiting to see if you also on your form, and when we're talking about forms, we're talking about this one right here. They want to make sure that also that you don't have in here answered no again a second time, because if they did, they can come back and then they can say, all right, we gave you more than one opportunity and you didn't disclose it twice. So absolutely, under any circumstance, make sure that you fully disclose. And when you get any kind of a request letter, seek assistance from counsel to figure out why they're asking for it, because it's often not as simple as just gaps in your history that you haven't included. So please be aware of that. All right. Okay, let's get to a couple more questions and then we will wrap up here. Let's see here. Who is next? Okay. So Choidy says, a friend of mine forgot to attach the diploma for the CEC application and had it refused. The fact of not sending the document could be interpreted as misrepresentation. This, depends upon what they included in their application. And this is the Thompson decision. Exactly is what this is. So there was a federal court case where they challenged the refusal. It's not misrepresentation for failing to include that document. Often, I'm sure your friend included a transcript or something else in that place, or a letter of explanation. But they may have an opportunity to challenge that in federal court, Chody, if they act quickly and depending upon the circumstances. So there are some, this is outside of our misrepresentation topic, but I strongly recommend that you have your friend reach out to us and book a consult so that we can talk to them about that. Okay, let's see who's next here. Okay, Sean says, do one has to declare traffic convictions in the US? No arrests were made and disposition resulted in fines less than $200. So go ahead, Alicia, please.
So this is a big question. And the problem is that around the world, there are some jurisdictions that don't have a criminal offense, but they have it as some sort of provincial or state or territorial offense. But it all depends on what Canada would equate that to under the Canadian Criminal Code or any other act of Parliament. So it has to be federal in jurisdiction. So if it truly would equate to something that is a traffic offense in Canada that's only under provincial jurisdiction, then it's probably, but it all depends on the circumstances, not going to be a criminal charge. However, if it's something that would equate, even if it's not an offense where it was done, if it equates to something in Canada that's a criminal offense, it could also make you inadmissible.
Oh, lost us here. We're coming back. There we go. I love that spider. That's my favorite thing. All right, let's get to another question. This one here is from Neil. And Neil says, what about the employer withdrawing a work visa in the US? Should that be mentioned? So this is kind of a tricky one, because what do you mean by withdrawing a work visa? So they started the process to apply, but yet they requested to have it withdrawn before a decision was made. Well, and as far as the work visa, it is your visa application, even if the employer is submitting a petition. Now, I guess the question is, if a labor market impact assessment in Canada was refused for an individual, well, really it's the employer's application. So I don't think that would be, constitute any kind of a refusal in the context of an individual. But yeah, we definitely need a lot more.
It depends on the stage, right?
Yeah.
Because if that person was already working and then the work permit was canceled or, withdrawn after it had been issued, then that might be something that could very well cause problems.
Mm-hmm. Okay, let's see what we have next. Okay, we'll pull up Halima one more time here. She says, if only keep the money for proof of funds in one bank only, should I still get letters from all the other banks where I have bank accounts? If you have bank accounts and you have money in them, then you're going to disclose it, even if it's not the funds that you are going to use for the purposes of your proof of funds. So when in doubt, disclose. Okay.
And get translations if it's not in English.
Exactly. Okay. All right. I forgot to check D of the background declaration. So D being refused. But I clicked on E and I disclosed the visitor record refusal. So let's just take a quick little gander at this. I got to make sure I've got a bunch of windows open here now, and I have to change this. Let's see here. Bear with me a second as I shrink these down. Okay, I think this should take us to where we need to go. We're kind of doing this on the fly, so hang in there, guys. Okay, so this one right here And I've been adjusting that size, so we can probably enlarge this just a little bit. I got lots going on here. Bear with me. All right. Okay. And I think I know what the problem is. Let me just go in here. Okay. So you can see here, and that is still pretty tiny. Just give me a second, you guys. We're going to try to get this here. And that's the one I want. There we go. Okay. So when we're looking at this one right here, I'm going to back this off now. The distinction here is between D, which is refused refugee status or a visa, visitor or otherwise. So that's D. And then this is being refused admission to order to leave Canada or any other country. So the question that was asked was, I forgot to check D. So I'm assuming yes to D, which is the visa refusal, but I clicked on E and disclosed the visitor record refusal in the explanation box. So I provided a web form with the updated checkbox D, any issues. So do you think they would be that cruel, Alicia, where you did disclose it, but it wasn't referenced specifically to, D or E? And here's the thing that I'll just point out here as we go back to this. If you look at the instructions at the bottom here, and maybe I can just enlarge this like this. Just give me a second here, see if I can enlarge it a bit here so we can see it. You can see here, it gives an open-ended section where if your answers to any of these questions is yes, provide details below. So I think realistically, if you didn't specifically mention here, which one of the things up here it relates to, like if you checked multiple boxes, then I don't think it's a big deal. But the problem for sure is right here, right? The problem is yes, no. And so I don't know. That's could they be that cruel? That's a question of ages. I don't know. What are your thoughts, Alicia?
Well, I mean, assuming that there's only one, right? That it's only D that is yes, that should have been yes. And you put E by accident, but E doesn't apply. E should have been no.
Mhm.
Then if you've put your explanation on the explanation box in the first application, and then you corrected that with a web form and you said, oh, I made a mistake, it should have been box D all the time, and I had the proper explanation at the bottom,
Yeah,
then I would sincerely hope that immigration views that as simply an error, right? You
yeah,
were always providing the information. It's not that you didn't provide the information. And this is what it comes down to is, did you provide the information or did you not? However, in your case, you would have mistakenly said yes to E, and I guess in your circumstance, it's not the case that you've been ordered to leave Canada, but it is the case you were refused that visitor visa. So technically, immigration could say it's inaccurate, right? You've provided
Mhm.
inaccurate information. But because you have put that explanation on the same form, on the same page, and then corrected it, I would sincerely hope that under the TR to PR application, if this is what you're looking at, I'm not sure what kind of
Yeah.
application. So it also depends on, did you do this under express entry or did you do this under the TR to PR?
Yeah. And I'm assuming that it's probably TR to PR with his reference to the actual letters. I'm assuming it's probably the Schedule A, but the principle applies equally across the board. Okay, let's take a look at this one for Abrazi. And I think what he's asking is, could you explain? And we did talk about this a little bit earlier in the video, in our presentation here. Other country visa refusals, how or what their impact is, essentially their effect on the Canadian visa application. So this is a
Mhm.
really important question that I'm really glad that this person asked it. So you know that many representatives, and I shouldn't say many, there's a lot of overseas agents that don't care about telling the truth. They don't care about the consequences. Their sole goal is to get a result for you at all costs. They will tell you not to disclose prior visa refusals because you'll get your application rejected or somehow it will look badly or unfavorably on you. So, Alicia, if someone has a visa refusal to the US, what impact does it have? And I want you to maybe address both a temporary application as well as a permanent one.
Mhm. And the court cases actually say that this is specifically relevant. And so If somebody has a visa refusal to the US or to some other country, it usually means that there was some reason that that other country decided not to allow them entry. And Canada, of course, you have to prove a temporary intent. You also have to make sure that you are not inadmissible or some sort of big, nasty criminal. And so if
Hmm.
another country has thought, well, maybe they're not going to go back to their home country, or if another country has done a background check on you and found something that could make you inadmissible, that's relevant for Canadian immigration authorities. So they always want to know. And also, depending on your type of application, it could be relevant to whether you have to go get a police certificate from that country because there's health implications if you've been living for a certain period of time in countries that have certain communicable diseases. So those are key reasons.
Yeah. Excellent. Thank you. So when in doubt, what do you do?
Disclose, always
Disclose.
disclose. You always
Always.
have to disclose. And the other thing to keep in mind is that if anybody is recommending that you not disclose something or that recommending that you misrepresent, that's an offense under the
Yeah.
Immigration and Refugee Protection Act. It is an
For them.
offense, yeah,
Yeah.
to counsel misrepresentation.
Yeah. It's an offense for them. All right. Okay. Well, we've got a little bit more here before the ghosts fully take over. Um, Raj says thanks for answering the question. Sean's got a little bit more. He says that he forgot to add foreign residence history in previous study permit, and I'm not sure exactly what this is. A previous study permit extension application, which was finally approved. The residence history is more than 5 years old. Should I tell that I had omitted? So, excuse me, I'm just trying to figure out what exactly, excuse me, you mean by this, Sean, when you forgot to add foreign residence history in the previous study permit. Did you not include everything that you needed? Or I don't know, Alicia, if you can make any sense of that one. Sometimes the
I'm
questions.
assuming I'm assuming it was, that the person had lived in another country but didn't put it on their prior address history or personal information.
Maybe.
So, and these things can always come back to bite you in the end because if you, let's say you're doing your study permit application and you want to apply for a postgrad work permit application. Well, as soon as you do that subsequent application, as soon as you put in your postgrad work permit application and you have to answer the questions on residence and address history and personal information, there's going to be a disconnect and immigration will probably wonder why. And so, yes, if it's something that is incorrect, taking the time to do a web form to explain what's going on. But if that's going to possibly trigger reevaluation of whether the officer should have given you the study permit or whether you might be misrepresenting something on your application, I would say please go talk to a lawyer about that.
Yeah. And that's, I think, one of the biggest lessons that we want people to understand is that this is serious business. And if you have any doubt, any uncertainty, any questions, don't take the chance. You've seen the case law that Alicia has presented early on here. These decisions, Malik and Hisham, are just they're just the tip of this iceberg of case law that supports the cruel approach IRCC takes with any error, omission, you know, that they, even if it's innocent. So, all right. IFTech says, hey guys, how to disclose US visa refusal in an FSW, LOE. So I'm wondering, IFTech, if now you're realizing, oh, dang, I forgot to disclose it. Well, if you have the ability to submit a web form immediately, you're going to try to correct the record before you get a request letter or a procedural fairness letter from an officer. If you're going to try to save an application from misrepresentation, you need to act as quickly as you possibly can. And obviously, if you're disclosing it proactively, an error that you made versus responding to a request from an officer who's already identified it and is just fishing to kind of trap you once again in that same misrep so they can hammer you with the 5-year bar. Yeah, that's definitely the approach that we would recommend. Alicia, do you have any other thoughts on that?
Yeah, if you haven't filed your application yet, right? Like if you just have your
Yep.
profile up, then you would be preparing a letter of explanation if the invitations to apply do start rolling
Yeah.
out. So it depends on what stage you're at in the application.
Yep. Perfect. All right, guys, we are just about done, and like I said, these the ghosts are taking over here. Happy Halloween to you, Janvi. Let's see. CS says I've been refused the visitor visa in order to leave Canada. It's Quebec. Okay. Well, that's sad. I'm not quite sure if we have any real answers. Uh, oh, well, here's an interesting question. He says, will the new minister, Sean Fraser, adjust the immigration policy dramatically? Yeah, they usually don't jump in right away. Usually you see dramatic changes in policy when there's a change in government. You know, when it's shifting from one political party to another, you might see. Usually, and I don't think the mandate letters have come out, but usually the ministers, they will, you know, they will continue on with the policy that was previously announced by the previous minister, because it's all part of that political party's campaign. You know, their platform for election. And so usually it doesn't happen that way. Usually, let's see if we have any other ones here. Let's see. Okay, here's one. This is a good one, Janvi. So while applying for Express Entry, I added my job title as associate, but the letter I got from my employer states it as associate operations. Will that be counted as misrepresentation?
And so employment letters are really important. There were some other cases that I found specifically for Express Entry that talked about, Mark was doing a presentation to the Canadian Bar Association on Express Entry, and there's been some recent cases that talk about employment history and how people are disclosing their employment history. And there was a recent case where the person had actually gotten a nomination letter, so a provincial nomination, and it was a different knock code than what they had put as their primary knock on their Express Entry application. And that ended up being a little bit confusing and causing problems. And the officer ultimately found, you know what? Even though you got an invitation, a provincial nomination, your obligation is to update your primary knock and make sure that your job letter accurately reflects that knock. And so it really, this seems pretty close, associate and associate operations, but
Yeah.
I don't know what knock you picked and whether that job letter can be backed up with, your pay stubs. Is there a title on there? Is it a matter of picking a different knock, or is this all fall within the same knock?
Yeah. Excellent. All right, let's see what else we have here. Let's see. Okay, so Uzo says, I've applied for a study permit on the 14th of September, but I omitted some information in my family information and 1294E form. What do I do?
So
You
family
start by
information
booking a
form. So I wonder,
consultation with us.
yeah, so I don't know
And
what information in your family information form
yeah,
did you not put? The family information form is really tricky because a lot of people don't realize that there's a slot for your place of birth and the date of birth and your occupation and your address and your occupation or the parent's occupation and address. So maybe it's something like that, but maybe you completely forgot to list a sibling or a half sibling or something like that. So if you've submitted an application and there's something wrong and you know there's something wrong, then please talk to a lawyer.
yeah. Okay, I'm just going to flip back here to one. So we kind of addressed this briefly. Raj says, can you explain the difference between D and E? So let's just jump in there and understand there's a lot, and when it comes to interpretation of this, and let's see if I can make it just a little bit larger here. Well, we'll go to there anyways. So D, you can see it's talking about visas. So it's talking about applying to enter a country and obtain permission through a visa or some other, like you're applying for a study permit, things like that, including a CSQ for Quebec or a PNP. So if you've applied, and this is the interesting thing, many people don't pay attention to this. If you've applied to a provincial nominee program, then you also need to disclose that if you were refused that application. So all of these are about refused applications, refugee status, a visa to any other country, or visitor or temporary resident visas. Well, what are temporary resident visas? What are those, Alicia? If we could kind of give some examples of a temporary resident visa.
Like a visitor visa.
Yep.
So
Yep. Work permit, a
study
study
permit.
permit, right?
Yeah.
And that's to Canada or any other country. So that's kind of what they're focused on here.
But also permanent
Yep.
resident visas,
Yes,
right? So
yes, yes, yes. Immigrant
yeah.
and permanent resident visa. So you applied for a green card to the U.S. and it gets refused. You applied to stay in the UK and a permanent, or Australia a permanent. And so it could be anything that even touches on it remotely. And then E is been refused admission to or ordered to leave Canada or any other country. Okay, well, if you've been refused admission, you could have had your visitor visa approved through a foreign consulate. You arrive at the border and the border officer asks you some questions, doesn't like your answers, and refuse you admission. So that's a pretty simple example. Someone who's coming up from the US, let's say, and they had a prior DUI or some other conviction or something, and they come to the border and the officer asks questions and the officer realizes, okay, you're inadmissible to Canada, so I'm going to refuse you admission. Ordered to leave, well, you've got a removal order, against you, and it's enforceable, and they've, ordered you to leave. A deportation order. Anything else, Alicia, in this category?
Well, I'd add that because of COVID, refused admission might be broader than it has been before, right?
Good
Because
point.
there have been
Yeah.
certain times when our borders have been only open if you can prove that there was an essential purpose for your visit. And people were getting turned away if
Yeah.
they couldn't prove that essential reason for entering. And is that a refused admission? Maybe
Yeah.
you might as well disclose it and put all those
Yes.
details down there.
Yeah. And like we said, in the context of a PR application, very rarely are either of these, grounds in and of themselves for denial of a permanent resident application. If you've had 5,000 visitor visa refusals to the US and you apply through express entry, those prior visitor visa refusal applications that you've had, they're not going to affect your admissibility to Canada unless there was something else associated with them, some form of misrepresentation or something else that an officer could try to link to another ground of inadmissibility. But just
Yeah.
the mere fact that you applied to go for a holiday to the US and got that application refused, in and of itself, it doesn't cause you to be inadmissible to Canada. But if you fail to disclose it on this form, then even a harsher consequence than getting your application refused is that they will find a 5-year, or they can and often do find, bar you from Canada for 5 years for misrepresentation. All right.
Yeah.
I think
And
we're
that's
oh yeah, go ahead, Alicia.
just the
Oh, look
last
at all
distinction
these.
I was going to make too on that case with regard to the primary knock and people picking the wrong knock or not being able to justify their work experience. That wasn't a misrepresentation case. That was just a case where
Yep.
their permanent residence application under express entry got refused. And so it's not always the case that any sort of error will result in misrepresentation. Sometimes it just results in the application being refused on substantive grounds,
Yep.
but sometimes it does. They go further and they find the misrepresentation, and that's the worst case scenario.
Yep. So Addie says here, I applied for TR to PR, but now I have my work offer renewed. Can I update with the web form of my new letter? I have not gotten AOR yet. Wait till you get your AOR. And if circumstances have changed, then go ahead. There's no harm in updating. Okay, let's see if we can wrap this up with the last couple questions here. Let's see here. Actually, you know what? I know what we're going to do here. We're going to do this right here. Going to start the music. That's the sign that we're going to wrap things up. Okay. Will student visas be stricter or more difficult under Sean Fraser? I think they're going to be about the same. Family reunification. Yep, they're slow, and hopefully we'll start to see some improvement. Okay, John V, you've got some other issues, my friend. He says there was an error, and I'll just turn this down just a little bit more. It says there was an error in my employment dates and details when I applied for express entry for the first time, but I corrected it in the latter stage. Will it be considered as misrepresentation? That's actually an interesting one, Alicia. So if you had a prior application and it was refused for whatever reason, but there was no finding of misrep, and then you submitted a second application and corrected it in this current application, can the old one come back and cause problems for you? And we may not be able to answer this one, Jambi. This is a tricky one. And I don't mean to put Alicia on the spot because we haven't seen a lot of direction from the courts on this. But
there is some case law talking about, how long or how far back can immigration go to look at misrepresentation, and it's very broad.
Okay. Thank you, everybody, for tuning in and joining in us on this special Halloween extravaganza. And we've got all kinds of stuff going on here. So as the ghosts take over and the spiders, we want to wish you guys a happy Halloween. Did they call it Dia the Dead? Dia dos Muertos in Mexico? I can't remember. Anyways, he says we need more of these valuable live videos. You're very welcome. All right, guys, take care. Happy Halloween and have a wonderful weekend. Thanks, Alicia.
Thanks, Mark.
Bye.